Hi, everyone. Thanks so much for being here with us today. My name is Shauna Rifkin, and I am the Deputy General Counsel at FAM. For any of you who are unfamiliar with FAM or less familiar with FAM, FAM is a sentencing and prison reform organization, and we advocate in the states and the federal system for a more fair and effective justice system. One of the primary tools at our disposal in advocacy, in sentencing reform is the federal sentencing guidelines. So after 3 years, we finally have a sentencing commission, but there's a lot of work to be done. As the commission's process to amend the guidelines gets underway, we wanted to have an event where we could talk about the work that the commission does and how it impacts criminal justice reform, and the legal landscape that has emerged in the past 3 years, and importantly, how this impacts real people. So with me today are 3 truly remarkable people who have so much knowledge and insight to share, and I'm really excited to introduce you to them. So I'm going to first introduce the speakers and then let them take it away. Mary Price is the General Counsel at FAM, and she has been at FAM for over 20 years and is a true expert in all things sentencing commission. Erica Zunkel is a clinical professor of law and the associate director of the Federal Criminal Justice Clinic at the University of Chicago. Erica was with the Federal Defender's Office in San Diego before joining the law school. And last, but certainly not least, we have Jamar Ezell. Jamar is a returned citizen who has since become an advocate for sentencing reform, among other things. It is a real honor to have all of you here today. And just one last thing before I hand the mic over to Mary, I want to forecast the format of today's event. So Mary and Erica will start with some thoughts on the commission and the state of the law. And then Jamar and I will have a conversation about his experiences, and then we will open it up to questions from all of you so that you can ask our panelists all the questions that are on your mind about the commission. So with that, I will turn it to you, Mary.
That's better. Thanks a lot. Hi, everybody. As Shauna mentioned, this is the First Amendment cycle in a number of years, and it's certainly the First Amendment cycle since the commission lost its quorum in 2018. And at that time, it also lost its power to amend the sentencing guidelines. But the First Amendment cycle has begun, and the stakes for this cycle, I think, couldn't be higher. The commission has signaled that it could take up a number of issues this year, but I think the real hot button issue confronting the commission will be amending the policy statement on compassionate release. And the heat comes from a question that has deviled the commission from its very founding, and that is, how much discretion is the commission willing to afford federal judges? So this is truly a pivotal moment and a real chance for the commission to take on a role it has shouldered before, and that is being a catalyst for sentencing reform. So for a number of years, the commission's been criticized, and rightly so, for guidelines that call for unduly long sentences. For one example, are drug guidelines. They're driven by drug type and drug quantity, and can and often do exceed anything necessary to achieve the purposes of punishment. And those aren't the only ones. And the commission's actions, often with encouragement by the government, have helped to build an enormous prison system, and one that's marked by excessive sentences and by racial disparity. But the commission has also been an engine for reform. One good example from the past is crack cocaine sentencing. Starting as long ago as 1994, the commission began to sharply criticize the mandatory minimum sentencing structure for crack cocaine. Powder cocaine mandatory minimum sentences relied on drug quantities 100 times greater than those for crack cocaine, and that 100-to-1 disparity, or ratio rather, was both unjustified by science and resulted in extreme crack cocaine sentences that disproportionately affected Black defendants. In 2007, the commission published another comprehensive report on the topic, and not its first, making the case for changes to the mandatory minimum sentences for crack. And the commission took another step. It lowered the federal sentencing guidelines for crack cocaine by 2 levels, but it didn't stop there. It made that guideline retroactive so that people serving sentences at the time of the reduction for crack cocaine could go back to their sentencing court and apply to their sentencing judge for that reduction. And over 16,000 people benefited from reduced sentences based on that decision by the commission. And then those actions by the commission helped spur congressional action a few years later. In 2010, Congress unanimously passed the Fair Sentencing Act, and it reduced the powder and crack disparity from 100 to 1 to 18 to 1. And while Congress didn't make that change retroactive for people who were serving mandatory minimum sentences, the commission mirrored those changes in the guidelines and then once again made that change retroactive. And finally, and eventually in 2018, Congress followed the commission's lead in the First Step Act and made the mandatory minimum changes retroactive and applicable to people who had been sentenced before. So that's just one example of the good that the commission can do and the influence that it can have. Another example, I think, is the compassionate release form in the First Step Act. I think one can draw a line from the commission's policy statement governing compassionate release that was amended in 2016 to Congress's amendment of the compassionate release statute in the First Step Act of 2018. So compassionate release was authorized by Congress in the Sentencing Reform Act, and it permits a federal judge to reduce a finalized sentence when a person has developed what are known as extraordinary and compelling reasons. And the statute gave the Sentencing Commission the job of describing those reasons. And the current compassionate release policy statement describes criteria such as medical conditions that can be grounds for a reduction in sentence. And the current policy statement also gives the Bureau of Prisons, but not judges, the discretion to identify additional grounds, which is discretion that the Bureau of Prisons is never used. So to understand why updating a commission policy statement has come to be so very important to the larger issue of judicial discretion, it helps to look at what has been happening in compassionate release litigation in the years that the commission has lain dormant. And so there were several key developments. The first one is there's been litigation in this ground. There's been compassionate release litigation, and that's new because by law, only the BOP could bring compassionate release motions to federal courts, and it rarely did. I mean, people who should have gone home were terminally ill, died in prison because the BOP neglected or denied the requests for a motion. And Congress in 2018 was fed up with the Bureau of Prisons' heartlessness. And in the First Step Act, it ended the Bureau of Prisons' control over compassionate release by amending the compassionate release statute to allow incarcerated individuals themselves to file motions. And that just changed the game for everybody. In the very first year after enactment, 145 people were released via compassionate release, which was more than double any previous year before. The second development is that starting in March of 2020, the COVID pandemic began to sweep the nation and hit prisons particularly hard. And nobody, and certainly not the Sentencing Commission, had anticipated a global pandemic. The commission's policy statement was silent on the subject, and nonetheless, tens of thousands of people filed motions to federal court, inviting the judiciary to recognize the vulnerability to COVID that people with underlying medical conditions had, and to recognize that as an extraordinary and compelling reason warranting early release. And the grant rates soared. A mechanism that had freed only a handful of people annually before the First Step Act led to the release of nearly 4,000 people at risk from COVID. The third thing that happened is while all this is going on, a group of visionary lawyers began to move compassionate release practice to an entirely new level. By statute, the judges who evaluate compassionate release motions have to consider applicable policy statements from the commission. But because the commission hadn't been able to update the compassionate release policy statement following the First Step Act, most courts have ruled that it's not an applicable policy statement, at least with respect to defendant filed motions, right? So that's because the policy statement only recognizes Bureau of Prisons filed motions and not defendant filed motions. So that opened the door to permit judges to identify compassionate release grounds other than those described in the Sentencing Commission or by the Sentencing Commission. And so people began bringing compassionate release motions that invited courts to reduce extreme sentences. And those included motions on behalf of people serving sentences that could no longer be imposed due to changes made in the First Step Act, such as changes to extreme mandatory minimums under 18 USC section 924C and 851 drug enhancements. And those changes affected sentencing going forward, but had not been made retroactive. And while the numbers aren't huge, we estimate about 230 people serving such sentences have been granted compassionate release in 2020 and 2021. And this litigation, as Erica is going to tell you, has spurred a great deal of conversation in the courts of appeals. So it means now, because we have a sentencing commission, it's going to be up to the commission to craft a new applicable policy statement, one that's aligned, obviously, with the First Step Act. And the commission is going to be faced with an important decision, and that is whether to preserve the discretion that many judges currently have, not all judges, but many judges currently have, to determine what constitute extraordinary and compelling reasons, or to constrain the discretion, and if to constrain it, how to do it and by how much. So I'm going to turn it over to Erica. She's going to talk about the state of the law in this area and the complicated and multi-layered circuit split that's developed.
Thank you, Mary, and thank you, Shauna and FAM, for having me today to speak about this really important topic, and in particular for focusing and always centering human voices and how they are impacted by these changes. So as Mary mentioned, the First Step Act was a game changer for compassionate release. And what we've seen in the last 2.5 to 3 years in the district courts and also in the circuit courts are judges, trial judges and appellate judges wrestling with what extraordinary and compelling reasons, what they mean, how expansive that definition is, and then how much discretion district court judges have to define those. And what has happened is the circuits and the courts of appeal are very split, I think evenly split at this point in time, as to the bounds of district court discretion. So Mary mentioned the sentencing changes in the First Step Act passed at the same time as the compassionate release statute was amended, because Congress clearly wanted compassionate release to be used more. The title of the change is, increasing the use and transparency of compassionate release. So many judges, I think, saw that as an invitation. This is a new thing for me to be able to do. It used to be judges had to wait for the Bureau of Prisons to make a motion, and now, after somebody has gone to the Bureau of Prisons and just said, hey, I'm requesting compassionate release, once they've done that, they can then go to the judge. I think other judges, this was something very new to them, and there was a hesitance to embrace the discretion that they have, and maybe a thought of, I wish there was more guidance on how this new power, how I can use it. And of course, as Mary said, the policy statement was outdated because it hadn't been updated for the changes in the First Step Act. So with regard to non-retroactive sentencing amendments in particular, this became a really hot button issue. Mary and I were in Florida speaking on a panel, and there's a federal defender there, Ezell Bashir, and he had a really good analogy that I now use for describing the circuit split on this. It's that internet meme where people were, some people saw a dress that was pink and some saw a dress that was blue. So the circuits are just in polar opposites in terms of how they're seeing whether judges should be able to consider changes in the law as an extraordinary and compelling reason for release. And the way this plays out for people is that people today, I go to my clients and I say, Congress changed the laws, and if you were sentenced today, your sentence would be lower. In many cases, it would be drastically lower. But I have very bad news for you. It's not going to impact you at all. You're going to remain in custody, and it's just for people's sentences will change going forward. And that to me feels like a very compelling and extraordinary reason to at least petition the judge and say, hey, take a look at my case, take a look at my sentence, given these changed circumstances, and given the fact that Congress really wanted judges to use compassionate release more. So where I practice in the Seventh Circuit, the court has very much cabined what compassionate release can be. And they have said that if you would receive a lower sentence today based on these new updates that Congress has made to sentencing law, that cannot be by itself or in combination with any other extraordinary and compelling reasons, a reason that a judge can rely on for release. They are joined by the Third Circuit and several other circuits in coming to that conclusion. And the basis for it really is what I think is a wrong statutory interpretation of, they say Congress, by not making these changes retroactive, essentially said this can't be an extraordinary and compelling reason. And that was their way of saying that. And that does not seem at all clear based on what Congress did. And I think there are many reasons why those changes weren't made retroactive that have nothing to do with what they may or may not have wanted. On the other side of the ledger, there are a number of circuits, including the Ninth Circuit, most recently, who have said these are legal changes that can be extraordinary and compelling reasons for release. The Ninth Circuit has decided they can be extraordinary and compelling if there are other reasons that are extraordinary and compelling. And then there have been other circuits that have decided, the 10th Circuit, that the changes can be extraordinary and compelling on their own. So this is what has been percolating around the country. And what it means is that there's a very different legal landscape for somebody who is bringing a motion for compassionate release based on changed circumstances. That is, their sentence would be drastically lower today in the 7th Circuit versus the 9th Circuit, or as Jamar will tell you, in the 3rd Circuit. And I think that that's troubling and problematic. And it's where I really see the Sentencing Commission has the obligation to lead in this area and show us what a robust policy statement can look like. And I think the first principle there would be do no harm as to what is out there in circuits where people can bring these changes, non-retroactive changes in their motions as extraordinary and compelling reasons. We certainly don't want the Sentencing Commission to say, no, you can't do that anywhere. So I think the Sentencing Commission would be wise to think about a policy statement that recognizes changed circumstances. We live in such a fluid world. We live in a world where criminal justice reform is going slowly. I don't think that these are things that we can necessarily anticipate. So it's going to be very important for the Sentencing Commission to create a policy statement that has enough flexibility where when the next emergency or the laws change or the government decides, and we don't even prosecute these cases anymore, that judges have the ability to take all of those circumstances into account in the extraordinary and compelling inquiry. So the big question now, I think, is what happens once the Sentencing Commission comes out with its updated policy statement. This world in which we have been litigating, as Mary said, except in the 11th Circuit, judges have said we are not bound by the policy statement. It's not applicable. It hasn't been updated. There are some places where district court judges are encouraged to look to the policy statement, even though it's not applicable, as having some guidance to offer on what might be extraordinary and compelling reasons. So there hasn't been unlimited discretion. But the question now is, one, what happens to all of this law that has developed? So I'm talking about this circuit split on the non-retroactive sentencing amendments. And I want to give a shout out to my UChicago law students, because they talk about all these issues with me and give me really great ideas. So I was just talking to a student last week, and his opinion is that once the Sentencing Commission comes out with a policy statement, that will be binding on district court judges. And it will be essentially, Congress has said, we are leaving it to the Sentencing Commission to define what extraordinary and compelling is. And judges are bound to follow that. If that is in fact the case, I think that there may be an argument that some of the law that I would say is wrongly decided and is bad would potentially go into the dustbin of history. And we would start out with the policy statement as being operative in terms of what extraordinary and compelling reasons are. Again, I think if that's the state of the law, that's a reason for there to be an expansive policy statement that retains district court discretion if it's binding. And courts have found other sentencing commission policy statements binding in other cases. I think an interesting aspect of whether the policy statement would be binding is it may actually have the effect of telling judges who right now may be very reticent about using compassionate release and wondering what are the bounds of their discretion once they see, okay, the Sentencing Commission has given us a whole host of possible examples of things that could be extraordinary and compelling reasons. I didn't have that information before. And so now I know, I can grant more of these motions knowing that this is something that the Sentencing Commission has really thought about and talked about. I think the other question is maybe the sentencing policy statement will be binding, but the question is, do judges still then retain a degree of discretion to decide what extraordinary and compelling is statutorily and outside of the policy statement? So this is a little bit in the weeds, but it's a question of whether is extraordinary and compelling one part of the test, then the test is it consistent with the policy statement? And then does the judge analyze the sentencing factors and how those go in? So I wish I had a simple answer as to how all of this will play out. But I think the biggest takeaways for people who are thinking about these issues and the Sentencing Commission is to really look at the law that has, look closely at the law that has developed in the circuits over the past 3 years and think about the fact that individual district court judges with some guidance in the policy statement, I would say, set a floor, but not a ceiling for what extraordinary and compelling reasons could be. So enumerating potentially some new reasons for compassionate release, but making clear that that's a non-exhaustive list, and then seeing what, there will then be a whole new, all types of new law that develops around the new policy statement. And the final thing I'll say is that I just saw today that the commission received 8,000 public comments on its proposed priorities. And so I think that is a clear statement from people that they want the Sentencing Commission to lead on criminal reform. They don't want us to go back. And so I think thinking boldly and leading on compassionate release in particular is going to have a huge impact and a good impact on our federal criminal system. So thank you again.
Thanks, Erica, and thanks for citing that number. I was going to drop a link in the chat later so that people can see the comments and the proposed priorities as well, because I think over 8,000 comments is extraordinary. So I mentioned at the beginning that one of FAM's primary tools of advocacy is storytelling. And I'm really excited to have Jamar with us today because FAM has been telling Jamar's story at the Supreme Court and at the Sentencing Commission, and now we get to talk more about his story with him. FAM recently released a federal compassionate release report that also features Jamar's story, which I'm going to send in the chat right now, so you can read up on that later if you want. But now let's get a chance to hear from Jamar and hear his story. So I'm going to ask him a few questions, and we'll have a conversation. Thanks for being with us, Jamar. I wanted to start, a lot of times I think when we talk to returned citizens, we start with what did you do? What happened? How'd you get there? But I want to start with what you're doing now. I want to start with where you are and how you're spending your time now in your freedom.
Well, yeah, right now. So I try to spend some time doing sentencing reform, being an activist in that. And I also been doing like moving and junk removal. And I just started CDL class. So
That's great.
Yeah, that's like most of the stuff I'm doing right now. Yep.
Great. Okay, so now we're going to go back in time a little bit. And you were incarcerated when you were 22 years old for armed robberies. And because of the stacking effect of 924Cs, you were sentenced to 132 years in prison. How many years did you actually end up serving?
So I actually did 18 years and 8 months in prison.
Okay. And I mean, 132 years at 22 years old is extraordinary. And you were not only able to survive, but you really, I mean, you really found, part of yourself. And I'm wondering if you can talk us through how, what got you through those long days of not knowing if or when you'd come home. How were you able to survive?
I just tried to keep a positive mindset and just, read and stay in the law books and research my situation. I dedicated a few days out the week to go to the law library and research, the law and stuff like that. And I always had faith that, I would be out one day, and, eventually it happened.
So you developed a passion for researching the law, right? And in 2018, the First Step Act passed. Do you remember learning about when that law was passed and what that was like?
So yeah, I was researching and I seen a case, and like soon as I seen it, like I was just like immediately like all over it, and I like within that next week I just started the process of doing everything I needed to do to try to get some relief from that, the same way. I don't remember the exact case, but yeah, it was the case where a guy had he had a lot of time like I had, and he filed the motion, and they granted his motion, and I really didn't look back from there. Yep.
Yeah, you kept moving forward, kept researching. And in
Yep.
your research, you came across a project by former Judge Gleason, who's now a commissioner on the Sentencing Commission. And Mary was speaking earlier about this group of extraordinary lawyers who push the envelope on compassionate release. And Judge Gleason really was that lawyer. And one of the cases that he took was your case. But Judge Gleason had an impact on your case even before the First Step Act. Can you tell us a little bit about that?
Oh yeah, so yeah, during my I don't know if y'all familiar with it's a 2255 is a motion that you got during your appeal process. So during that time, I was granted an evidentiary hearing, and before my hearing came up, I received a letter from my judge, and in the letter, my judge mentioned a case called United States versus Holloway, and Judge John Gleason, he was residing over that case. And I read the letter, and the letter basically stated that in that case, Judge Gleason asked the court and the United States attorney if they could drop a few counts so he can help out one of the defendants that he was residing over. So eventually, they granted the case, and the guy got 2 of 924C counts off.
Okay, I'll continue just while Jamar is away. I'll continue telling a little bit about his story. So essentially, Jamar wrote to Judge Gleason's, sorry, not Judge Gleason, Jamar's judge wrote to him and asked if there was a way that he could use the strategy that Judge Gleason had used in the Holloway case. And because he was upset with the mandatory minimum that he had to impose in Jamar's case. And his judge was unable to give Jamar relief in that instance. But then after the First Step Act was passed, Jamar wrote to Judge Gleason and told him that his judge had also been really dismayed by the stacking effect of 924Cs. So Jamar received a 132-year sentence, but if he was sentenced after the First Step Act, he would have received a sentence of about 20 years. So that's a huge disparity. And this time around, Jamar had a tool to address that disparity, and that tool was compassionate release. So Judge Gleason ended up taking Jamar's case. And Jamar's case is pretty extraordinary for a number of reasons. His case was in the Third Circuit, and his judge released him in February of 2021. Shortly after February of 2021, the Third Circuit issued a decision called United States versus Andrews. And in United States versus Andrews, the Third Circuit, which is what Erica was referring to, said, you can't use these retroactivity arguments about the punishment that someone would receive pre and post First Step Act as a basis for compassionate release. So what that means is if Jamar had brought his motion even a few months later, he would still be in prison today. And I think it's a really striking example of just the stakes of these issues and the stakes of these cases. And having Jamar with us, even though he had some technical issues, having him with us for a little bit to tell his story is really important because his story is one that is shared by many people. We communicate at FAM, we run a compassionate release clearinghouse, and we communicate with people in federal prisons all the time. And a lot of them, the first question that unfortunately we have to ask now is, what circuit were you sentenced in? And that answer dictates the relief that we are able to try and help people with, but that's not how it should be. It should be that across the country, you can have sentencing relief based on the same factors, no matter where you were sentenced. So I think I had a question for Jamar about what he would want to say to the commissioners if he could. Hopefully we'll get him back. So I think that's a question that only he can answer, and I don't want to put his words in his mouth. So I think at this point we can go to some questions. If anyone who's attending has a question, please feel free to drop it in the chat or use the Q&A function. But for now, I'll ask my questions in case. Oh, sorry, Mary, did you have something?
Can I just add one? Can I just add one thing, which is something that Erica referred to, and I think maybe this is the time to talk about it. I'm not sure, but it isn't. I see the opportunities right now not just about second chances, compassionate release, although that's a huge issue and obviously one that we want to preserve. But I just wanted to, pick up on what Erica said. The judges have used their discretion to reduce prison terms for people released on CARES Act home confinement, for example, who were then returned to prison by the Bureau of Prisons for technical violations. And some courts have used compassionate release to free people who have been who had to deal with pretty appalling conditions in the Bureau of Prisons or medical care or lack of medical care, more like it. Sexual abuse survivors are beginning to explore using compassionate release based on their trauma. And then, there's just all the grounds we don't even yet know about. I mean, we said earlier about the pandemic, COVID taught us that there's not a guideline that can capture every event. So being sure to sort of build in the capacity to identify and be able to act on something that can't be enumerated is, I think, critical to a healthy sentencing system. So I just wanted to add that because Erica made me think about sort of those other grounds that were. Yeah,
that's a great point, Mary. And I think that makes me think about a question. I mean, what you're talking about, the reason we know about those things is because we have interaction with people who have had those experiences. And I think this commission has already signaled their openness to people's own response and own involvement in the commission's advocacy. So I was wondering, and the reason I'm saying that is because the commission recently decided that they're going to allow incarcerated people to submit responses to the proposed priorities and to the amendments themselves, which I don't think has ever happened before. I don't know if it has, Mary, you would know better than anyone, but I don't believe it's ever happened before. And so as we're thinking about that, and as we're thinking about the amendment cycle, I was hoping you could give us a little bit of sort of what are the next phases in the amendment cycle and how can people get involved to share their story and to share experiences that they may have that we may not have thought of because they haven't happened to us, but they have lived them.
On this Friday, the commission is going to meet to vote on the priorities that is floated. Among them, obviously, is amending the policy statement about compassionate release because it's old and outdated, and there are some other ones in there as well. So the commissioners will meet and they'll vote on which priorities to adopt for this amendment cycle. And then the next set of steps have to do with actually coming up with proposed amendments. Now, by law, the commission has to present amendments to Congress by May 1st of next year. So May 1st of 2023, they have to come up with a slate of guidelines that have to be that they would like the Congress to allow them to enact, basically. And Congress has from May 1st, I think it's 6 months until November 1st to disapprove those. And if it were to disapprove any of the amendments, it would have to do so by a majority vote of both houses, and that would have to be signed by the president. So generally, those tend to go through without too much trouble. But so May 1st is sort of the drop dead deadline for everything. So working either forward from here or back from that, the next sort of steps have to do with what are those guideline amendments that the commission is going to recommend that Congress allow it to promulgate. And that begins with obviously this identification of priorities, and then the commission will begin to put out or publish for comments a set of proposed guideline amendments. And those proposed guideline amendments will presumably track some of the priorities that we've seen. And the public will once again be given an opportunity to publicly comment on those, just as we did for the priority cycle. The commission also tends to have at least one and sometimes more than one public hearing where it invites witnesses to testify about one or more of those policy statements that it's or amendments to the guidelines that it has floated out there for us to comment on. So there's this process of getting input in writing and also in a back and forth with commissioners about those. And this all then leads them to the process of finally voting for the final guideline amendments and final policy statements or new guidelines and new policy statements that they need, then that they will propose to Congress no later than May 1st. And the commission, and forgive me, because I don't think I have easy access, but the commission's actually put on its website, so helpful, sort of a little bit of a calendar that you can look at to see roughly when these things happen in the ordinary course. But this will all be unfolding over the next number of months. And we and you who are here at this webinar have the opportunity, obviously, to participate in the comment period. And we really encourage people to do so. And as Shauna was pointing out, the commission has made itself available on core links and invited commentary from people who are incarcerated in the federal system, which is we point out a first. And I'm just super heartened that they've done so, because obviously the interest in things that the commission does is super high in that community. Hi, Jamar, welcome back.
Hey, Jamar, welcome back.
Hey, how y'all doing? Sorry about that.
That's okay. So I finished sort of telling a little bit about what happened at the end of your case, but there was really one question that I was hoping you could talk a little bit about that only you can answer. And, you know, your story really demonstrates the success of compassionate release. And unfortunately, there's a lot of people in many circuits, so including where you were sentenced, who cannot be released for the same reason that you were released today. So as the Sentencing Commission begins its process to consider amending compassionate release, I was wondering what you would say to the Sentencing Commission, to the commissioners as they begin this process.
I think it's like real simple. I think I would just say let judges judge, because you know, with mandatory minimums and stuff like that, you limiting judges from judging, and with this, you know, this is another thing that's hindering the judge from doing his job. So I just feel like if we're gonna have judges, we need to let them judge, and I think that would be the best remedy.
That's great. I love that. Let judges judge. And that very much ties in with what Erica and Mary were talking about with the, you know, the promise of judicial discretion and allowing judges the space to actually do their job and judge. So thinking about, thanks, Jamar. So thinking about judicial discretion, Erica, you had mentioned that, you know, some judges, when they have an applicable policy statement, whenever that comes out, if the applicable policy statement allows them, you know, sort of just discretion, it may make some judges feel better because they'll have this policy statement that's now applicable. But what about judges for whom they look at a policy statement that says, you know, you now have discretion and that's sort of it? Are you worried at all about what they will do and whether they will release people at all, or whether they'll say, you know, I have discretion, but it's not clear how to use it? And does the answer to that question make you think that, you know, the policy statement should have a enumerated basis? And can you talk a little bit about the value in both of those things with judges?
It's a great question, Shauna, and one I'm thinking a lot about, because I think that the commission has, they have to strike the right balance. I think that they want to, again, you know, in line with what Congress's intent, that compassionate release be used more, provide avenues for judges to do that. I think that there are many judges who are embracing that discretion, have been very happy during this 3-year period of time to be able to think creatively and define what kind of changed circumstances are extraordinary and compelling. And it's important to note that that doesn't mean that that person is automatically let out. The opportunity to go to the judge and say, I have extraordinary and compelling reasons for release, the judge still has to consider, is release consistent with the sentencing factors? And so that this is, you know, for people who say, oh gosh, there are gonna be so many people and judges aren't gonna be able to keep up. I mean, this will remain a narrow avenue for relief, just in the way that Congress has framed it. I think the right balance is we do want to encourage judges who might be more hesitant to use compassionate release. Maybe they think it should be a medical reason. And Congress was very clear when they passed the first compassionate release, when they passed compassionate release back in the 80s, that it was about changed circumstances. And those could be medical, those could be non-medical. It was, that wasn't something that Congress felt like compassionate release was only a medical thing. So I think leaving discretion, the same discretion that the Bureau of Prisons has right now to define other reasons, keeping that there, but giving judges examples of things that might constitute extraordinary and compelling reasons. And those might be taken from what judges have been doing in these last 3 years. I think there are many examples, but as Mary said, we're not going to be able to think of every single possible example for the decades to come. And so there has to be flexibility in there for judges to continue to define them on their own. So I think giving examples, but not saying that those are exhaustive, is very important.
Thanks, Erica. That's great. I have 2 questions from the audience that I want to make sure I get to. So what do you all predict that the current makeup of the commission will do on these questions? How do you predict that this current commission will address these questions? I know we talked about one commissioner already, and how he was involved in Jamar's case. So that may make us hopeful, but I'm wondering if, what the rest of you think about that.
I'm happy to jump in, and I'd love to hear others' thoughts. One of the things that is heartening about the Sentencing Commission, it is required to be a diverse group of people, and I do think they take seriously receiving comments from a diverse host of people who are involved in the criminal system. I think it's heartening that there is a former federal defender on the commission. I think that is a voice that has often been lacking, and I don't think there can be any real conversation, robust conversation, substantive conversation about moving the federal system forward to be more fair and just without federal defenders involved. So I think that that's heartening. Obviously, what Mary and Shauna were saying about soliciting comments, the amount of public comment, I think that the public must feel that, that there's a real value in speaking to the commission, sharing their stories. I am a defense attorney, so I am cynical by nature because I tend to lose, all the time. But I remain optimistic that this really is a moment for the Sentencing Commission to again be a leader.
Thanks, Erica. Mary, do you have any thoughts? I know some of these commissioners?
Yeah, I can't predict. I won't even try. People are remarkably, they always surprise you. And I mean, I have a great deal of, as I almost always do going into a cycle, I have a lot of optimism about what the potential is. And, some of the questions that they've asked in terms of the things they want to look at are really encouraging, right? I mean, they have to look at compassionate release, but some other things in the site, in the list of priorities that they didn't have to talk about. And I'm encouraged by that. And I have to echo what Erica had to say. I mean, the Department of Justice has had rather a thumb on the scale at the commission for a long time because it has an ex officio member is from the department and another ex officio is from the parole commission, which I'm not entirely sure why, but there really hasn't been, except by virtue of a practitioners advisory group and a statutory obligation of the defender's right once a year to the commission, there really hasn't been anybody who's had the kind of in the room influence that that people who are on the commission have and the department has had. So I do feel very encouraged about that. I mean, I also felt really encouraged by watching these commissioners during before they were commissioners during the sentencing hearing, the Senate Judiciary Committee hearing, because everybody talked about coming to agreement and working together and not coming in with preconceived notions. And I think there's a lot of good faith there, and I think a lot of interest in working together. So let's see.
And I know we've come back to this a few times, but I think one other hopeful thing is that they are for the first time inviting comments from incarcerated people. So they're relying on the voices of incarcerated people, not just the voices of people in the Department of Justice or defenders or other advocates. And that seems truly extraordinary. And I just wanted to get your reaction to that, Jamar. I mean, you had talked about how, being in the law library and working on your case really gave you hope and purpose while you were incarcerated. And I was wondering what you think about the commission now inviting comments on priorities from incarcerated people.
Yeah, I think that's I do think that's a good thing because you get a perspective from the people on the inside also. I think it will also be a good thing with maybe some correction officers too, because they watch a lot of us in the prisons, and they see what type of people a lot of us is. So that'll also be a good input if that was possible. But yeah, I'm pretty encouraged that that they would do the right thing. I kind of believe that one person on the commission would, vote the right way, and that's Mr. Gleason, and hopefully he have a lot of the others to follow him. Yep.
Thanks, Jamar. I appreciate that. Mary, were you going to say something before I? So we have another audience question about old law prisoners. And so the person's wondering what will happen with old law prisoners who cannot file motions with the sentencing court and can only get compassionate release from the Bureau of Prisons. Is there anything through federal sentencing reform that can help them?
It requires Congress to act to enable them to use the compassionate release statute. It's a little complicated why, but the compassionate release statute only applies to people sentenced after the Sentencing Reform Act was enacted in 1987. And people who were sentenced, who are called so-called old law people who are sentenced before that, aren't covered by the provisions of the Sentencing Reform Act. And what that means is they have to apply to the Bureau of Prisons, who would then ask the judge to advance their parole eligibility date. I think is how it works. It doesn't happen. And they're extremely sad cases. I think there are several hundred people stuck in this situation where if they were covered by the current statute and by the current guideline, those who were terminally ill and who were seriously ill or facing COVID complications or who had served a number of years and had reached a certain age, all of those people would be at least eligible for consideration by the courts, but right now the courts have no discretion to revisit their sentences absent that kind of two-step that I described earlier, which simply doesn't happen. I'm sorry, it's an appalling state of affairs, and there is a bill in Congress to fix that, but I don't think that it's going anywhere.
I think the other thing to think about, and I think about federal compassionate release and the backdrop of the lack of other ways for sentences to be revisited in the federal system. But as Mary was talking, I was thinking this would be an area where federal clemency would be very important as another safety valve. And I think the federal system should have a functioning compassionate release program, clemency program, ideally a second look law, like what was proposed several years ago by Cory Booker, but we don't have that, which is why I think compassionate release also is very important. But those are cases that if we had a better structured functioning clemency system, I think would be high priority for categorical relief.
We have about 6 minutes left, and I have maybe 2 more questions. So we talked a little bit about the circuit split, and hopefully the commission will be able to do something that will address that circuit split. But I think that remains a question mark. And if the commission can't fix the state of the law in a way that addresses that circuit split, then it seems like bringing a case to the Supreme Court is really the only option. And I'm wondering if you agree with that, Erica, and what you think it would take to get a case to the Supreme Court, because there were 3 cases, I think 3 or 4, that went to the Supreme Court around this time last year, including the one where we wrote about Jamar's story. And those cases were all denied cert. So in other words, the Supreme Court did not accept those cases and is not reviewing them. Do you think that having a commission will change that? Just wondering what your thoughts are about the court.
I think that the Supreme Court, and this is not just in the compassionate release area, but other areas of the federal sentencing guidelines, where the Supreme Court has said, we really want the Sentencing Commission to have a quorum and be working so that they can begin to address some of these issues that we feel like are in their domain, and that we would prefer not to have to weigh in on it. So I suspect that the Supreme Court is hoping that the commission can fix this issue and thinks about it, thoughtfully and can resolve it. As I mentioned earlier, I do think it's a question of what happens to the law that has developed in this without an applicable policy statement, where there's a bit of a vacuum. Does that still put limits on judges' discretion, even if a compassionate release policy statement says non-retroactive sentencing changes can be a reason, one of the reasons for compassionate release? And if that is happening, where the Sentencing Commission comes out with that kind of a policy statement and people are bringing those motions in, like my circuit in the 7th Circuit, and the 7th Circuit and judges are still saying, hey, that's all well and good, but we're still bound by the case in the 7th Circuit is Thacker. Then I think the Supreme Court is going to have to weigh in, and the Sentencing Commission is going to say, well, we tried to fix this, and we have this conflict with law that's on the books and is related to different issues, and so it may be that the Supreme Court is the only one who can resolve that conflict. But the Sentencing Commission coming out and making their own statement about how they think that those changes should be treated, I think should have a big impact on federal district judges, appellate courts, and the Supreme Court ultimately.
You might just add something. I said earlier that you can draw a line from, the Sentencing Commission's amendment back in 2016 to the First Step Act's amendment of compassionate release. And that's because when the Sentencing Commission addressed compassionate release again in 2016, it changed some of the criteria, and it added, or it took away, some limitations on, who was terminally ill and that sort of thing. But one of the things that did was it sort of put the statement in the commentary, which was basically directed directly at the Bureau of Prisons, and it said, look, I mean, it didn't say it like this, but I'm going to paraphrase it. He said, look, if you find that there's an individual who meets these criteria that we've just laid out in this policy statement, then get those cases to the judges, because it's judges, and by implication, not the Bureau of Prisons, who can determine not only whether they meet the criteria, but second, the most important question is, do they deserve to be released? Do they meet the other criteria, the sentencing criteria that we're familiar with? And the Bureau of Prisons just, ignored that admonition entirely, that encouragement entirely. And after that, some senators wrote to the Bureau of Prisons and said, so how are you doing with this? Are you bringing these motions? And months later, they get a letter back from the Bureau of Prisons and the Department of Justice saying, well, no, we didn't. And they had these like very small numbers of people who had been released. And that did it. I mean, the senators turned around and they wrote a new law, and that new law became was a Brace Act, and it became part of the First Step Act, and it went into law in December of 2018, and completely changed the face of compassionate release and led to this conversation that we're having today. So I know we're up against time, but I just wanted to say that that's just another example of how the commission has an influence on everything, even if they can't directly change something. Okay, that's all.
I think that's a really perfect note to end on, Mary, and I appreciate you saying that. And before we close, I just want to thank all of you, Mary, Erica, and Jamar, for joining us and having this conversation today. And I want to thank everyone who participated. I hope that you all learned something about the Federal Sentencing Commission and about the potential that this amendment cycle really has to shape criminal law going forward. It is a really significant cycle. And FAM will continue to put out on social media and in emails ways that people can be involved in advocating for sentencing reform this cycle. So thank you all so much for being here today, and I hope that you have a wonderful rest of your day.